Hello and welcome to Module 2 of Partner Visa Secrets. I hope you've taken time to digest everything we covered in Module 1, maybe work through your notes, had another coffee, and now ready to dive into Module 2, the practical real side of this training, and really where I can start to give you some real recommendations on how to strengthen your case before you look to submit something to the government. So let's jump straight back into the slides. Once again, probably quite a long session, maybe not as long as yesterday, but still a lot of things to cover nonetheless. So just to recap, we went through Module 1, we're now up to Module 2, which is the important partner visa requirements and strengthening your application. Now, just to quickly lay the framework for the next module, Module 3 is where we talk about tools, but I will also be delivering some special offers to people that do attend Module 3, for our products and services. But today is all about Module 2. Now, quick recap, where we left off in Module 1. It's all about evidencing the color blocks for the visa you're applying for. Remember, you want the yellow blocks if you're applying as a de facto couple. You want the red blocks or block if you're applying as a spousal couple, or the green block if you're applying as an intent to marry couple for the 309, and then yellow for the PMV. Probably should have chosen another color for PMV, but not that creative. So just a recap of where we left off Module 1. So let's get into it. Part 4, the 4 aspects. Okay, as we know, the aspects really are everywhere and dictate what they're looking at. So just again, to visually represent what you're trying to do, you're trying to evidence the 4 aspects of the relationship for all these applications. Household, financial, social, and the nature of your commitment tie into each of these blocks, all these requirements. Bird's eye view: household, financial, social, nature of commitment. Let's get into it. Your aspects will be collectively assessed, okay? Meaning that you might be weak in 1 or 2. So let's say, using this diagram as an example, let's say you are weak in the financial aspect, okay? You maybe don't have joint bank accounts, or only recently opened up joint bank accounts, but you have been cohabitating, you do live together, have lived together for quite a while. Socially, your friends and family are aware of the relationship, supportive, you have proof of their support, you've got well-written statements from them, photos surrounded by other people, no questions regarding your social aspect. You clearly demonstrate yourself to be in a de facto or spousal relationship, or you've clearly indicated to others that you intend to marry, for those applying for a PMV. And the nature of your commitment aspect, maybe that's not really in question either. You've been together for a while, maybe you are engaged, maybe you do have a civil union, maybe you are married, maybe you have organized wills, maybe you've done a few other things that we'll talk about in the rest of this module shortly, that really suggests the nature of your commitment is quite strong. Now, the idea that I want to get across to you is that you can be weak in 1 or 2, but still be strong in the others and still be okay, because it is collectively assessed. They're going to look at everything as a whole to determine if you meet the requirements or not. When I say meet the requirements, I mean that you've tipped the scales to indicate that you are in a de facto relationship with your partner, or you are in a spousal relationship, or you do intend to marry, and that you're not just boyfriend-girlfriend, boyfriend-boyfriend, or girlfriend-girlfriend. You're not just dating, you're one of those things, depending on the visa you've applied for. So you just need 51% of your documents, let's say, to prove that you are one of those things. Okay, it's not about being 99%, because that's not how relationships work. That's not how documentation works. That's not, every case is different. So the department have to look at this holistically in assessing couples' facts and documentation. So therefore, it's about understanding your specific scenario under each aspect. So we're going to start talking about relationship scenarios and what you can do to strengthen each one prior to lodgement. Strengthening each aspect helps to strengthen your entire application due to the collective assessment principle that we just covered. Okay, so because your application is collectively assessed, anything you do now up until lodgement or even post lodgement to strengthen any of these aspects is actually going to strengthen your entire application because they look at everything collectively, as we've just covered. So let's now look into Part G, weight scores and recommendations. The concept of weight scores, okay? Within each aspect, you would place a weight score according to your scenario. So each aspect, the 4 aspects, we would place a weight score on your scenario. We're going to talk about the scenarios in a second. Scenario weight is relevant to tipping the scales overall. So what do I mean by this? Let's recap quickly what household cohabitation. Now, what they're going to look at, again, these were the things that we looked at in the law yesterday. The law says case officers must assess the following factors. They must assess any joint responsibilities for the care and support of children, the living arrangements of the persons, and any sharing of the responsibility of housework. Okay, that is the nature of household. That's that aspect they're going to look at. So you will likely, therefore, fit into one of these scenarios. Now, I would say the scenarios at the top are the best weighted in the sense of that aspect can't get much stronger based on that scenario, working all your way down to the weakest scenario for that aspect for couples. So let's start at the top. You have jointly purchased property with your partner. You can't get much stronger of a household aspect than that, and you're living in that property. I mean, jointly purchased property not only is a very clear indicator of a couple cohabitating and maintaining a home together, but it also ties into other aspects. It ties into their financial aspect because very likely they've had to both apply for mortgages and loans, their financial liabilities. That's also part of the financial aspect. It also ties into the commitment the couple have to each other because they've committed to that together. So therefore, jointly purchasing property together can't get much stronger of a scenario when it comes to household and cohabitation. Then we work our way down from there. I would say couples that have a joint lease alone as a couple is a really good scenario. The lease is a very good piece of evidence that a couple are cohabitating. It's a legally binding contract between the couple and a third party, and it's a financial liability that they're sharing. They're both responsible and jointly liable to pay the rent in that lease. So not only is it good proof of cohabitation, but again, it's good proof of the financial aspect of that couple. Then we have, I would say beneath that is property owned by one party, living together with shared utilities. So this often, I suppose, represents itself as the Australian partner typically owns property because they're the ones here. They're the ones that have their place. And the migrating partner comes and moves in with the Australian, but the property was purchased by the Australian before they met and it's in his or her name. But they live in that premises owned by the Australian, but they have shared utilities, so they share the other expenses of that place, but it's not owned by the couple together, and the mortgage repayments are still paid for by the Australian sponsor. That to me is still a good scenario because you are living together alone as a couple, and it's explainable as to why the migrating partner doesn't I suppose contribute to the expenses of that property aside from shared utilities, because the property was purchased and maintained by the Australian sponsor before the relationship with the migrating partner. Then we kind of work our way down from there. Property rented by one party and the other is an approved guest. So this isn't the Australian sponsor owning the place. It's more as in the Australian sponsor having their own place. They're renting their own place, and the migrating partner, maybe because they don't have work rights, they're not able to be put on as a tenant, so they're not jointly responsible for the payment of the rent, but they're acknowledged to be an approved guest. So the real estate agent has acknowledged that that partner is an approved guest and they're living together. They're sharing utilities at that place. So, the electricity bill's under one person's name, the water bill's under the other person's name, but it's not their jointly rented premises, but it is their home. Okay. The reason that's different to a couple that actually have their own place and have their own lease is that a joint lease is very different to one party being on the lease and another person being an approved guest. it's not as legally binding, and it's not as strong. It's not a third party issued contract for both applicant and sponsor. On the one document, a lease under one person with someone as an approved guest won't hold as much weight as a couple that rent their own place together. Especially when couples rent their own place together, if they're paying, let's say, for the rent together, through their joint accounts. But nonetheless, it's still a good situation because they're still living together. It's still their place, but they're just not on the lease together for whatever reason. I mean, if that's your scenario, I would recommend though that you do try to pay the rent together, even though it's not technically required because the other person isn't on that lease. You can still pay the rent from a joint account, and we're going to talk about that in the financial aspect. That's arguably how you might be able to strengthen that scenario, work your way up. Then we have, scenario 5, joint lease. So you do have a joint lease, but you live with other people. Now, yes, you have a joint lease, but there's other tenants. The reason we would put that mid-range is what we prefer is for couples to have their own place if possible. Because arguably, a couple that live together on their own have an easier go at demonstrating the nature of their commitment. Arguably, a couple that live together on their own can demonstrate that they are de facto in a married relationship more so than couples that might be sharing accommodation with other people. Arguably, couples that live with other people maybe aren't yet ready to live together on their own. That might be how it's looked at by a department case officer, kind of skeptically or cynically. So you got to put yourself in the position of a case officer. So, that's why we put that there. It's still mid-range. We're starting to work our way down, but it's mid-range because at least you live together. You are maintaining a home, but it's it's with other people. So it's not the same as maintaining your own home together, just you two. Work our way down, more or less similar, I would say. Property provided by an employer. The reason that is weaker as a scenario is that when property is provided by an employer, or let's say living with family, is that it becomes more difficult to start accumulating documentation, official documentation that proves someone lives there, prove that both people live there. You start relying on what I would say secondary evidence. You start relying more on statements from people or statements from family members rather than officially issued documents such as leases and rent receipts for people that actually live together and have their own place together. So that's why these scenarios start to weaken, is because it affects and influences the types of documents you can collect to prove that you are both there, both living there, and that is your home together as a couple, and you maintain that home like a de facto couple, not just dating. You're not just boyfriend, girlfriend, or boyfriend, living with family, or living at a place provided to you by an employer. You are living there as a de facto or spousal couple. And then that covers scenario 7 and 8. And then we kind of have the final scenario, which is never live together due to travel restrictions, limitations, or just can't be in the same place. That is obviously not a good scenario in terms of trying to strengthen this aspect. Okay, so the starting point with this is firstly understanding that these are just examples, but secondly is trying to identify which of these best relates to your relationship. What's your current household scenario? And importantly, what can you do from now until you submit an application to try to move up these scenarios? Because ultimately, that's, if you want to strengthen this aspect, it's about trying to work your way up. I'm not saying you need to go and buy property together. I'm not necessarily saying that you need to go and get your own place, and get a lease alone. If that doesn't fit your financial scenario and not your intentions as a couple, it's just understanding that there's going to be different scenarios. There's going to be 50,000 other partners that are submitting applications, and they're all going to fit under one of these. It's about trying to strengthen yours as best as you can. So how do you do this, right? So that's great, Martin, but give us some recommendations. And these are my recommendations when it comes to strengthening the household aspect specifically. Put your partner on the lease if possible. If you can't put them on the lease, put them as an approved guest. Okay, so put them on the lease. I preferably, if you can't do that, at least get proof that they are there as an approved guest. Show you are using joint funds and you decided to buy furniture for your home together. So you're using the joint funds to pay for furniture, pay for rent, and that you're pooling money together to pay for property-related expenses in future. So you're saving money to pay for something that's related to your property, your place where you're living in your future. You need a new lamp. You've got a water bill coming up. You're proving that you're saving money to pay for the property expenses. Put your partner on any bills, even if they don't live there. So get your partner, typically the migrating partner, on the bills. So it's often not an issue getting let's say the Australian sponsors proof of living in a premises. Typically, we run into problems or limitations in migrating partners having proof or link to property. So put the bills under their name. So if one partner is on the lease and you can't get the other partner on the lease, put that other partner as the account holder to all the utility bills that refer back to that place. So at least you've got the lease, let's say, under the sponsor's name, and all the utility bills under the applicant's name. Show any online deliveries for the applicant or sponsor being delivered to the Australian address. Show any communication between partner and freight transport companies discussing pricing to ship their items to the property. If you have lived together previously, see if any old previous pictures together at the Australian address are geotagged. So if you've taken photos at your current place or lived together at prior places, if you've taken photos at those places, you can extract the geotag data. So you can look at your phone, you can swipe up on an iPhone and see where that photo was taken, and you can use that as part of your evidence to prove you were physically there, because it's about proving you are living there, as in you are both physically there, and that is your home, maintaining a home. So you're arguing not only are you both there, but that is your home as a couple, not just as friends, but as a couple. And show communication between you and your partner choosing a property, talking about your home. So if your partner's overseas or was overseas at the time and you were looking for a place for when they were coming in, or if you're currently living apart and you're looking for a place, show your communication in getting that place together. And then obviously you prove once you do move in together, but you can even show the build up and the lead up to when you actually started to cohabitate. To the financial aspect. So that was the household aspect. Now we're up to the financial aspect. The law says case officers must assess the following factors. Okay. The financial aspects of the relationship include any joint ownership of real estate or other major assets. So that ties into the household aspect, as I said. Any joint liabilities. Same thing goes with leases and mortgages. So that's why I said no, they don't just relate to one aspect often. Documents can relate to multiple aspects. The extent of any pooling of financial resources, especially in relation to major financial commitments, and whether one person in the relationship owes any legal obligation in respect of the other, and the basis of any sharing of day-to-day household expenses. So those are the factors they're going to look at to determine if you're in a de facto or spousal relationship, or even if you intend to marry. So, common scenarios when it comes to looking at couples' financial aspect. Same thing at the top. Best weighted scenario, let's say, in terms of the types of evidence you'll probably be able to collect. Joint Australian accounts, or let's say slightly weaker option, overseas joint bank accounts if you live overseas, being used to pay for expenses. Bonus strength, using joint mortgage offset account and ATO tax lodgements. So what this is trying to say basically is having joint bank accounts and using that joint account to pay for your living and relationship expenses as a couple. Okay. There's some bonus strength items there in terms of if you have a mortgage offset account and lodging tax returns as a couple, which we'll talk about in module 3. Scenario 2, individual bank accounts. So you don't have joint bank accounts, but you're transferring funds to each other to pay for living expenses. Okay. So you're still pooling your finances, you're still sharing expenses, but it's not as neat or as clean as a joint account. You're having to prove it using your individual bank accounts and show your transfers and highlight those transactions and annotate those documents. So there's more work involved. And arguably having a joint account is a larger financial commitment to each other than just transferring funds to one another. So that's why we place that beneath, having actual formal joint accounts together. Scenario 3, joint Australian accounts being used sparingly. So you have joint accounts, but you don't use them. So what matters is relevant transactional history, not just having a joint account. So I would rather that you are using your individual bank accounts and actually transferring money to one another to pay for your relationship expenses together than having a joint account and not doing that. So having a joint account doesn't mean anything. It's about using it. Okay. Now, I'm just going to quickly jump to my whiteboard because what I want to draw here is what I would say is our optimized financial framework. And this is most relevant to couples onshore, but certainly couples that are overseas can apply elements of this. And if you're currently living apart, you can make plans to have this in place, hopefully once your partner comes in, because you've taken my advice and recommendation from module 1 and you're going to try to bring him in on a temporary visa first. So this is what I would say is our optimized financial structure. You have the applicant's individual bank account, and you have the sponsor's individual bank account. And then you have their joint account. In an ideal world, the applicant and sponsor would transfer funds on a recurring basis, let's say every time they get paid their salaries, into their individual accounts, transferring a percentage to their joint account. And then this joint account is used to pay for expenses, rent, groceries, bills, living, relationship expenses. Plus, the couple have additional savings accounts, okay, that are used to demonstrate to the government, that they are saving, pooling their finances for things they plan to do in future as a couple, such as home deposit, wedding, having a baby, buying a car, whatever it is you see happening in your relationship. You're trying to indicate to the department, these are the milestones you intend to have. This is how committed you are to each other. And this is the money we're putting aside every week for those milestones. So not only does this strengthen your financial aspect by having something like this, but also strengthens the nature of your commitment, the plans you have as a couple. Because it's one thing for you to say in your relationship statement, let's say that you plan to marry, or that you want to buy a house together, or that you plan to have kids one day. But it's another to say that and then prove it. And this is what this does. By having your financial accounts optimized and set up somewhere along, this kind of diagram helps you to optimize your financial structure. Okay. And this is the recommendation we give primarily to any couple that are here together, or any couple that will be here together. And look, it's not always applicable. There's going to be scenarios where one partner may not be working, and that not all of those elements may be applicable to you, but it's about trying to get something along these lines in place in your relationship as soon as possible, and then use this account, use this structure for as long as you can, prior to applying for your application. So scenario 4 was individual bank accounts with limited to little transfers to one another. So that's, another example is, let's say you're relying on Western Union transfer. So you and your partner are living apart, your partner's overseas, you're here, you don't have Australian joint accounts because they're not here, you don't have overseas joint bank accounts because you're not there, you don't transfer money to your individual bank accounts necessarily because you probably rely on things like Western Union or TransferWise or other currency transfer options, to financially support one another. Now that's quite common when it comes to certain, let's say, offshore-based relationships or relationships that are separated, but I wouldn't say that that's a safe scenario to be in if you're applying for an onshore application. You are together. You do have the option to open up a joint account here. So scenario 4 is some couples are forced, that is what their financial aspects looks like. But if you're not forced to be in that scenario, you should be trying to work your way up. You really should be aiming to have joint accounts established early on and get transactional history, relevant transactional history, which is these expenses that I kind of quickly mentioned in my whiteboard, for as long as you can prior to applying. And lastly is scenario 5, which is individual bank accounts with limited to little transfers to one another. So that means there's kind of no proof that you are financially supporting each other or transferring funds to one another. So again, which of these scenarios best relates to your relationship, and what can you do from now until application to move up? And there's going to be some things you can and can't do depending on your scenario, such as you might be living overseas together where you can't open up joint accounts because of the country you live in, or your partner might be here not working. They might be here on a visa that doesn't allow them to work. They don't have a personal Australian account, so there's no way for them to transfer funds in. So there's going to be limitations that exist and apply to certain couples, and please don't feel threatened that the visa is going to be refused just because you can't open up a joint account. There are sometimes recommendations and things that we can suggest to strengthen those types of situations. It's just about understanding, though, that it's about doing what is available to you and trying to strengthen your financial aspect, to the best of your ability, as best as you can prior to applying for the application. So some financial recommendations, okay? Show you are pulling money together for your intended futures together. So that was what I drew in my whiteboard. You can try joint PayPal accounts. So I've seen that in the past where couples that are living together overseas, they can't open up joint accounts, but PayPal in certain scenarios allows you to open up joint PayPal accounts. In the scenario where your partner's living overseas and you're here, or let's say you're both living overseas and only one of you has an Australian account at the moment, the migrating partner, so the applicant, has transferred money to the Australian partner. So the applicant transfers money to the Australian partner. The Aussie partner opens up a sub-savings account in their personal account and calls it joint account with John O'Malley. So that's an example name. So, in that scenario, they're not here yet. They're coming. You don't have a joint account yet, but you have, the sponsor has their Australian account. That's Australia. They have their Australian ANZ account, and the migrating partner, that's the globe. Poor graphic. Transfers their savings, obviously factoring any conversion losses, or a portion of their savings. I'm not saying you need to absorb large currency conversion costs. I'm just trying to give recommendations and trying to strengthen a scenario like this. Transferring their funds to the Australian sponsor, and the Australian sponsor then opens up, a sub-savings account and calls it, renames it on their online banking profile. And that recommendation applies to the other scenario I was talking about in terms of having those sub-savings accounts. Rename them on your online banking portal. Take a screenshot of your online banking portal. It's going to show, wedding, home deposit, baby. In this scenario, it's joint account. So they're renaming it kind of unofficially as a nickname, the joint account, the Australian applicant. The migrating applicant transfers their savings to the sponsor. The sponsor then transfers that money into the joint account. And then you talk about that. You talk about that in your relationship statements. You say, the applicant isn't here yet. We've opened up, however, in the interim, a unofficial joint account. They transferred money into that account on this day. This is the money we put into it in anticipation of their entry to Australia and us starting our lives together. Some Australian banks do allow you to open up a joint account with the applicant overseas. The applicant can actually deposit money directly into the joint account, so not necessarily to the sponsor's personal account and then the sponsor transferring to their sub-savings account. I mean, in this scenario, the applicant transferring directly into a joint account in Australia that's been opened by the sponsor. The sponsor goes and opens that account. Some banks allow you to do that. I know Westpac is one of them. Transfers money into the joint account. However, just understand that some banks allow you to transfer money in, but you can't withdraw until the applicant enters Australia and physically attends a branch. So just keep that in mind in terms of liquidity and being able to withdraw and access the funds quickly and easily, that there might be limitations there. Couples that do not have or cannot get joint accounts should demonstrate financial support, i.e. money transfers instead, as I said. So if your scenario is you just cannot open up joint accounts, either here in Australia or overseas, then you do need to be relying on things like financial transfers to one another. Typically speaking, that's the Australian sponsor financially supporting an applicant, more often than not. If you are living overseas together, often many countries do not permit joint accounts. Do not worry. However, you may need to demonstrate bank transfers to from each other and explain this in your relationship statement. So again, if your scenario is you live in a country that for the last 2, 3, 4 years just has not allowed you to open up joint accounts, that's fine. That's understandable. You just need to explain that in your relationship statements, but still talk about and evidence and address how you have been financially pooling and sharing your expenses as a couple. The social aspects, okay? So up to 3 or 4. The law says case officers must assess the following factors. The social aspects of the relationship include whether the person represents themselves to other people as being in a de facto or spousal relationship with each other, and the opinion of those people, friends and acquaintances, about the nature of the relationship. So what do your friends and family think? And any basis on which the persons plan to undertake joint social activities. So, certain scenarios when it comes to the social aspects. Let's start from the top again. Both families and friends circles are aware and supportive of the relationship. Bonus strength, using social media. So the reason I would say that's the best weighted scenario in terms of evidencing the social aspect is that will directly affect and influence you being able to get supporting statements, statutory declarations and witness statements from those closest to you, which is often a key type of document in proving that you portray yourself to be in a de facto or spousal or intend to marry relationship, and that they believe you are. Okay, so if your friends and family are aware and supportive, often that influences the ability to get the types of documents from those people to prove that to the department. Scenario 2 is both families and friends circles are aware, but one side is not supportive of the relationship. So people are aware, but only one side is supportive. So the types of statements or documents you'll collect will be more weighted to one side than the other. So logically, that won't be as strong as couples that can get supporting statements from both sides. And I'm going to talk about the pyramid analogy in terms of who to get statements from in a minute. So, scenario 2 logically isn't as well weighted as scenario 1 because it influences the types of documents you'll be able to get. Scenario 3 is only one side of the family are aware of the relationship. So the other side are just not aware at all and obviously aren't supportive because they're not aware. And scenario 4 is neither side is aware of the relationship. Okay. So now what I'll say is that the social aspect, I feel, becomes most relevant in 2 scenarios. Firstly, in relationships where there's age gaps, I feel that the social aspect plays a larger role, particularly in ensuring you get supporting statements from those that are aware of the age gap and are willing to comment and talk about the age gap in their supporting statements. Now, I would say that typically where age gaps might be scrutinized more often is generally when you have a younger male visa applicant and an older female Australian sponsor. In my humble opinion, I feel that naturally case officers may be less understanding and accepting of those types of relationship dynamics and will probably be more inclined to question the motives of a visa applicant if they are younger, a lot younger than their female sponsor, and especially if that applicant comes from a certain region or part of the world that may be known for fraudulent or misleading documentation and information statistically being provided to the Australian government. And they know all that stuff. The government know where, let's say, high-risk applicants may be more likely to come from. So, if all those boxes are kind of ticked, I think you can kind of expect a bit of scrutiny from a case officer, or a lot of scrutiny, depending on what the dynamic is. But nonetheless, irrespective of who is older or who is younger, if there's an age gap, I think it's always important to comment on it, particularly in your relationship statements as the applicant and sponsor, but also from the supporting statements from hopefully both sides of the families. Again, which best relates to your relationship, and what can you do from now until application move up? The other scenario, I'll just say, where I feel the social aspect is most sensitive and has to be approached sensitively, I find in my experience, in our experience, is in same-sex relationships. And it's very common and normal for one side to not know, not be aware, and certainly not be supportive, especially if we're talking and dealing with cultural, religious, and social pressures from typically where the applicant is coming from. And that often influences who they might be able to get statements from, and they have to be, they want to be careful and conscious of who they get statements from. So just to say that it's very common for relationships in that scenario to lack, statements from both sides sometimes, and that's okay. And it's about understanding that happens, talking about that in your relationship statements, and again, kind of circling back to the collective assessment principle that I spoke about earlier in the module. You may be lacking a couple of documents here or there in the social aspect because the reasons beyond your control, but it's about strengthening the other aspects as best as you can. So some social recommendations. Okay, how to improve this aspect specifically. Take screenshots of your video Zoom calls with you and your families. Okay, so if you guys Zoom, video call, WhatsApp, Skype, so many now, your families, and typically, let's say it's the applicant's family from overseas because they're typically the ones not in Australia, take screenshots of your calls, you and your partner speaking to the family, even if they don't speak English, even if the Australian partner doesn't speak the language of where your family or where the applicant's family is from, it's still great evidence to show that they were on that call. Show family group chat transcripts with each other engaging with your family. So I don't know about you guys, but I have about 4, 5, 6 different family group chats, typically all on Messenger, but I might have a couple on WhatsApp. And it's, me, my brother, my sister, my wife, her sister, me, and my mum, my dad, my wife, her mum, just all these different kind of groups, all families. So showing that you guys are part of each other's family group chats is great social proof that they know about the relationship, supportive, and they're talking about it. You're talking with them. It's clear evidence that you're portraying yourself to be at a certain, in a certain type of relationship, because you go into the effort of inviting them into a group chat. You don't just put anyone into your family group chats. That's carefully protected, I find. So a good recommendation. Increased importance on Form 888s, specifically stating that they consider your relationship to be de facto and spousal in nature. Yes, so Form 888s are important, and they must specifically state that your relationship is de facto or spousal in nature. So it's not just about them saying they know you're in a relationship. You want them to specifically say they know you are in a de facto relationship. Those words exactly. Or they know you are in a spousal relationship. And then everything else. Okay, you want them to express that phrase. Text message transcripts between you and friends, family, where they know about your relationship. So if you've communicated send text messages or messages to friends and family, and you've celebrated a milestone in your relationship with your friends and family, you've spoken about it with them, that's good social proof. We would place increased emphasis on well-evidenced social aspects in cases where there are age gaps, as I mentioned before. On average, we see anywhere from 5 to 10 witness statements. A combination of Form 888s and overseas stat decks use the pyramid of power approach to supporting statements. See whiteboard. Okay, let's get into the whiteboard. Pyramid of power, as I've called it. So, what we're talking about here are witness statements. And the approach that you want to take in getting witness statements from your friends and family is to get statements from both sides, firstly. So you want to try to get statements from the applicant's side and the sponsor's side. Secondly, you want to try to get more statements from people at the top of the pyramid, because typically these are people that arguably are closer to the applicant and sponsor, would be in a better position to comment about the genuineness and nature of the relationship of the applicant and sponsor. And that is people that are the immediate family members. Immediate family members. And I mean parents and siblings. And that's not always relevant, but just a general approach. Okay, immediate family members. Try to get statements from both sides of immediate family members. Then we would have, I would say, other family members. Cousins, aunties, other people that are close to the applicant and sponsor. And then I would say, friends, colleagues. Okay, so work your way up from the top, work your way down, both sides. Then I would say Australian statements, so witness statements provided by those in Australia and also Australian citizens or permanent residents will arguably hold more weight than statements made by people overseas. The argument there, the logic is that statements written here, particularly if they are Form 888s, which are templated stat decks, statutory declarations, templated statutory declarations. They are official statements that hold a lot of weight, and they can be completed by people here in Australia. So what I would say is I would emphasize trying to get more statements from people here in Australia. So typically that means a bit more of a reliance or weight on the sponsor side, because typically it's their immediate family members, other family members, and friends and colleagues that are the Australians or permanent residents. And typically, the applicant, their family is overseas and they're not Australian citizens, permanent residents, and they're not here. So just keep that in mind. However, and I don't want to confuse you, but just to clarify this, people overseas can complete Form 888s. It's a misunderstanding or misconception that only Australians here or permanent residents here or people here can complete Form 888s. That's not true. You can give Form 888s to family overseas. However, that's not my recommendation. My recommendation is you keep it simple. Keep the Form 888s here, for people in Australia because they're here. Try to get as many from Australian citizens and permanent residents as you can. And then, typically the applicant's family overseas, get them to write their statements on whatever the official statutory declaration or affidavit or declaration form is in their country. So every country has its own declaration type form. And my recommendation is just get, let's say, the applicant's mother to write her statement on that declaration form. Okay, so let's say Italy has, an Italian statutory declaration. She writes her witness statement on the Italian statutory declaration. What you want to do, though, is you want to make sure that what she provides in her statement mirrors what the Form 888 asks of people writing statements here. And basically, the Form 888, which you can Google, says, how do you know the applicant? How do you know the sponsor? How long have you known them for? Why do you think the relationship is genuine and continuing? Is there anything else you'd like to say? And basically, it's about her structuring her statement, her Italian statutory declaration, to mirror the structure of the Form 888, provide the same information and her opinion on the same areas of the relationship as someone completing a Form 888 here, but in the form that makes sense over there. So get it to write it on the Italian statutory declaration, and it can be in Italian. It doesn't need to be in English, but if it's in Italian, you need to get it translated. Now, if you're applying for an onshore partner visa, it needs to be translated by a NATI accredited translator. If you're applying for an offshore partner visa, documents not in English need to be translated by whoever is authorized in that country to provide translations. That's a very vague description. I do apologize, but that really is the guidance given by the department. So every country might have their own authority. Let's say registered translation authority in that country might be one starting point, or contacting the local Australian consulate or embassy and seeing if they can direct you to an authorized list of translators that they can recommend. But for those onshore, it's very simple. You just go and find NATI accredited translators. If you Google migrationtranslators.com.au, you're going to find a few of them. Okay, so when you approach it in this way, you get one from the father, one from the mother on this side, two here, maybe one here, maybe two here, maybe, two here. You've got, what are we up to? Got 1, 2, 3, 5, 7, 9, right? Just by approaching in this way and spreading out where you gain statements from, you're going to quite naturally, I feel, get anywhere from 6 to 10. And I think that is a perfectly sufficient amount. As long as you're placing greater emphasis on getting statements from people at the top, working down, more emphasis on Australian citizens and permanent residents, but still trying to get statements from both sides, and especially making sure that they comment on age gaps, that they comment on the relationship being de facto or spousal specifically. And that, ladies and gentlemen, was the pyramid of power. Nature of commitment, the final aspect, okay? The law says case officers must assess the following factors: the commitment to each other, which is the duration of the relationship. So how long were they together for before they applied? The length of time they lived together for before they applied. The degree of companionship and emotional support that a person draws from the other, and whether the person see the relationship as a long-term one. Okay, that's what they're going to look for. So let's look at some scenarios. Scenario 1, and these I feel are quite logical. Okay, long-term married relationship at the time of application. So you are in a long-term married relationship before applying for a visa. Can't get much stronger of a scenario there in terms of the length of your relationship, how committed you are prior to applying, how long you've lived together for most likely before you applied, and what you see your futures to be, because you've already been married for as long as you have. Then we work our way down. Long-term de facto relationship. So not married, de facto, but you have a civil union and are engaged at the time of application. Work our way down. Long-term de facto relationship and engagement at the time of application, but no civil union. Okay, so long-term de facto relationship, engaged, but no civil union. That's the difference between scenario 2. Short-term married relationship at the time of application. So this is where I think maybe things get a little bit contradictory. Yes, sometimes we say being married might be better than being de facto, but at the same time, I would prefer for a couple to be together for a long time as a de facto couple, even if they don't have a civil union, but they're engaged, but they've been together for a long time, versus a couple that are recently short-term and married, as in together for a short time and then married and then looking to apply for a partner visa. That's not a good combination of sequences. You don't want to rush the relationship milestones. You don't want it to feel fabricated and unauthentic. So short-term married relationships, I feel sometimes can be scrutinized more than relationships that are longer in length, are not married, but are clearly de facto. Work our way down though. Short-term de facto relationships. So short-term, you're not married, you have a civil union though. Okay, but still short-term. And then lastly, short-term de facto relationship, you're engaged, but there's no civil union. Okay, so I think what this, if you look at this, if you break this down, marriage better than civil union. Length of relationship, though, is also important, and engagement isn't as good as civil union. Okay, so civil union has a practical benefit. Okay, and that's, if we look at the bottom left-hand corner of this slide, being engaged doesn't mean you are de facto. It's just a factor in your weight score. So being engaged is good, but it doesn't have a direct purpose. Whereas a civil union, registering your relationship in Australia as a civil union in most states, except for, as I've said in other modules, in WA and NT, waives the 12-month rule. So that's why we say, I would rather you register your relationship as a civil union than get engaged. Because a civil union will waive the 12-month rule. Engagement will not. So, as always, we end the summary of the scenarios with which of these scenarios best relates to you and what can you do from now into application to move up. And really, there's only a handful of things when it comes to the commitment of your relationship. It's wait longer, so be in a longer relationship before you apply, or get engaged, or get married, or consider civil unions. I mean, those are some of the tools available to you to strengthen this aspect. Move up in the scenario, so you strengthen this aspect, so that you strengthen all aspects collectively. So commitment recommendations, again, to reiterate, registering your relationship as a civil union is still possible even if your partner is not physically in Australia. Okay, just so you know, you can register if your partner's not here. You need to check with your state the process and requirements, but it is possible. Relationship length at the time of application is relevant, meaning if you're inside an Australia and have time left on your visa, it is often strategically advisable to wait to apply and allow your relationship to naturally strengthen before applying, i.e. never rush your Australian partner visa. And that's the title of probably one of our first Partner Visa Secrets branded videos on our YouTube channel. Probably one of our most viewed. If you do watch any video when it comes to partner visas, aside from all this content, that's one of the most important. So, pay close attention to my Secret Pillars of Strength slide coming up. So, all of this has to be in place at the time of application, okay? Because we looked at the requirements. You have to prove you're in a de facto relationship or spouse relationship at the time of application, not time of decision. When you submit the partner visa application is when you need to have those cover blocks in place. The only exception to that is the prospective marriage visa, which is where you can actually use the processing of the application to keep proving you intend to marry. So PMV couples, you have a little bit more leniency, more options, more time to strengthen your case. Couples applying for onshore 82801s, offshore 309-100s, and you're trying to prove de facto or spouse relationship, you're assessed at the time of application. So it doesn't matter if you apply today and it takes 12 months. Yes, they want to see you're still in a de facto relationship then and still in a de facto relationship then, but they're going to want to see you in a de facto or spouse relationship when you apply at the time of application. So considering the 12-month rule, remember to consider the 12-month rule if you're in a de facto relationship. Remember, getting married or strengthening your case after lodgement is not sufficient. Okay, so what you do post-lodgement won't matter as much as what you do pre-lodgement, unless you're PMV. Okay, use any time you have available to strengthen each aspect individually, which will in turn strengthen them as a whole. So using this timeline, right? You met, you start dating, you move in together, you open up joint accounts, your relationship is known to your social circles, you've been together longer, you apply for the partner visa. Strengthen those aspects before you apply. This is why it is important to be organized early in your timeline. If you're watching this training early in your preparation phase or research phase, trust me, you're going to be in such a better position than couples that watch this training later and then try to do all these things quickly. And never rush into applying. And guys, that wraps up Module 2. Now, Module 3 is the final bit of all this, okay? And we're going to talk about the difference between improving your facts and proving your facts, okay? And when I say proving your facts, really what I mean is about trying to get certain documents in place that really strengthen your application. All these aspects, all these recommendations that I've given you for all of these aspects, and trying to strengthen your case prior to application. You know, before a visa is submitted, what can you actually collect? What actually matters? We cover in the secret pillars of strength. Okay, that's a section dedicated to talking about what we would like to have in place before we submit any partner visa application. Okay, so there's certain documents, certain things that we work with our couples that we're preparing applications for to get in place before we apply. We're going to talk about them in the secret pillars of strength. I'm going to give you practical lists to work through. I'm going to work through another partner visa puzzle metaphor, and it's talking about how certain documents will hold more weight in proving you're in a de facto or spouse relationship. It's about covering a picture. So proving a picture to the department, certain documents will be larger pieces. It's about trying to get as many of those pieces as you can. And we're going to talk about cool tools. So cool third-party tools that will help you in the physical preparation and management of your documentation for the partner visa as you're preparing it. And then we're going to go over a money hack, you know, how you can save money in the visa application fee. And that's money that you save immediately just by kind of attending that part of that module. And guys, that was module 2. Not thankfully not as long as module 1, but still quite substantial. Module 3 will be more or less about the same. However, the difference is that at the end of module 3, after we go through all the content and summarize everything that we spoke about, I will actually be delivering a special offer to those that attend module 3 that will relate back to our VZ coaching and subscription. So couples that after watching all this content would like our help and coaching and support in the preparation of their own application, I'm going to be presenting an offer to people that attend. So please do attend. I mean, attend anyway for the content. But if you'd like to see what that offer is and are curious, tune in tomorrow and I'll show you exactly how we can help you and your partner. So I'll see you guys tomorrow in module 3. Bye-bye.